Time for thinking real estate. Laura Dwyer Schlecky, longtime real estate mogul,
1983. Been in
city
the line
councilwoman,
2 years on that.
2 years,
2 years coming up. I was elected 2 years ago in November.
and her partner in crime,
Bill Schlechte.
Schlecky.
Long
Morning, Bill.
time attorney.
Yeah,
You've
you-
been a long time.
You been out of town?
I was out of town, yeah. I had a variety of cases going on for the last 2 weeks. But I think also Laura was just as happy that I wasn't here so that she could have some guests on who didn't give her any
Flack?
rep. Yeah, no sass. Right.
Although people,
Or did they? I wasn't able to listen because I was in meetings or in court.
or I
Or
won't
what?
say.
No, we had some good calls last week.
Yeah, we did.
Yeah,
Keep those calls coming in.
Sure.
So what is the number? 787-3397?
it is.
Okay. Keep them coming in.
Okay.
All right.
You don't want any dead air because people won't just,
Mo-
they'll dial,
mo-
theyll go past the dial, so. go
Moving
ahead.
right
What do
along.
you want to say?
Oh, well, what do you want to say? Oh, wait, do
No,
you have any
no, no,
shout outs?
I don't have any.
Okay. I do have one announcement, and then we can go into real estate topics. I have a neighborhood meeting. This is my council hat on. Neighborhood meeting on Monday at 6:30 at the Calvary United Methodist Church at 925 Bacchus, but get to it off of Lansing Avenue, because the hall that we'll be in is, the parking's off of Lansing. Everybody's welcome. We'll talk about the stormwater.
And the leaf pickup and
And the
everything
leaf
else,
pickup
all of
and
the
any other
controversial
updates.
issues? Okay.
Anything else you want to talk about?
Deer feeding.
Deer feeding. Jackie said, "Don't feed the deer because she's almost hit almost hit several in her area, which is down by Essex Heights.
There's
Well, they're
usually-
coming in off the park.
Yeah.
Urban living. They want urban living. They're ahead of their time." Okay, so what's happened to you this week? You've been busy.
I've been busy, yeah, doing a variety of things.
And you said you had a question regarding time limits and purchase agreements, which I think is a good question. So if I put a time limit in a purchase agreement, here's this offer, and you have until Monday at 6 p.m. to respond, and you don't respond as the seller until Tuesday, what's the consequence?
Yeah, let me back up a little bit, because a question arose in the context of continuing education class that I'm going to be conducting next week out on the west side of the state. And the issue that I've been asked to address is whether time is of the essence in a contract. There's a legal term of art called time is of the essence. And you often see that clause in a contract where it says time is deemed to be of the essence with respect to the performance of the party's obligations or something like that. Michigan has held that you can either put that clause in there, or alternatively, and usually in lieu of that, you'll see a definite time limit set for removal of a contingency or the deadline for closing or some other obligation to be performed by one of the parties. Michigan courts have long held that the inclusion of a specific date means that time is of the essence. The parties wouldn't have put a date in that particular contract if they didn't intend that it be a date certain. However, there are cases that go on to say that although that is time is of the essence, the parties can waive either through specific words or through their conduct that particular provision. So even though the courts start off with the premise that that date must be met, they are willing to look, when I say they, the courts are willing to look beyond the language of the contract itself to see if the parties either verbally said, let's extend the date, or simply by their conduct, for example, after the date is passed, nevertheless, the parties continue to treat it as if the contract is still going. By their conduct, have waived that particular provision. So you have to be careful when you say, okay, it's 5 p.m. on September 15. If something doesn't happen, this deal drops dead. You start with the premise, that's it. Okay, that is time is of the essence. But
Is there a difference between the time response and a acceptance or rejection of an offer versus a time response and a removal of a contingency?
Possibly. The first one, it would depend upon how important a particular term was to the parties, and that might require testimony from the parties as to, hey, look, this really made a difference, and it seems to me
Like
that
a home inspection.
yeah,
would
home
be a typical
inspection
one.
or
I have to have it removed within 10 days after final acceptance. Our purchase agreement reads you have to have the home inspection removed within 10 days after final acceptance
acceptance of the offer.
of the offer.
Yeah, that one I would say is less important than one that said if you haven't accepted this offer by 5 p.m. on September 15, the offer automatically terminates. That's pretty much a date and time certain. When you've got an inspection contingency of 10 days, and the parties, because the inspector can't get out there, they're busy, and the period of time for closing is, let's say 3 weeks or 4 weeks after that removal of the inspection contingency, that might be deemed more waivable by the parties, and a court could
More
look at that.
adjustable?
Yeah, adjustable.
I wouldn't say waivable.
Modifiable, how's that?
Okay.
So that period of time might get extended. But again, an inspection contingency is a pretty important contingency.
Right.
I'm thinking more in terms of closing. You get down to the closing date, the agreement says closing shall happen within 10 days following removal of contingencies, but no later than, and there's a date. Well, what happens is the contingencies get removed, but the bank has an issue, or there's a title issue, something happens, and so now the closing has to be extended out a little bit. That's probably going to be a more modifiable date than the contingency removal. It's interesting because...
But even if I write an offer and I say you have to accept or reject this by 5 p.m. on Monday, whatever the date is, September 16th, and I get another offer in, I can withdraw, and they haven't responded, I can withdraw that offer, correct?
Well, you raise another really interesting and an unknown point, and that is when somebody puts in an offer and says, this offer shall remain open and capable of acceptance until 5 p.m. on Monday, September 16. That can, when it's given to the when it's given to the seller, and the seller says, okay, I now have until 5 p.m. on Monday, thinking that they can now go around and shop this particular offer with other buyers that may be interested in the property, they have to be careful because Michigan court cases held that the buyer who made that particular commitment, who said this offer shall remain open and capable of acceptance until 5 p.m., that the buyer can withdraw that offer before 5 p.m. on Monday unless that promise to keep the offer open and capable of acceptance until 5 p.m. is supported by consideration. So if the seller wants to keep the buyer from revoking that offer, the clause has to read, for and in consideration of the sum of $1, receipt of which is hereby acknowledged by the buyer, the buyer agrees to keep this offer open and capable of acceptance until 5 p.m. on Monday, September 16th.
So then the buyer can't withdraw the offer?
Right, because remember that a contract in Michigan is only enforceable if it's supported by consideration.
Oh.
And so this is a mini promise by the buyer in the offer to keep it open and capable of acceptance until 5 p.m. If there's no consideration for it, buyer can withdraw. It's not a contract, it's simply a gratuitous offer. I hate to get too legalese on that. But so
Thank you. We'll have to address it in our purchase
from the
agreement.
seller's point of view, you got to be careful. You sit there and you say, hey, I got until 5 o'clock on Monday, I'm going to shop this offer with somebody else. And that somebody else doesn't come through, and the first buyer withdraws the offer before 5 p.m., seller now has no offer on the table capable of acceptance. So you got to be careful.
What if, I just had the situation where a buyer came in, offered more than asking, the appraisal came in at asking price, or at list price, I'm
Right.
sorry, and they offered more than list price. So the buyer has asked that the seller accept the appraisal value, and then we adjusted seller's concessions. In the
You mean that's
meantime,
after the offer had been accepted and everything was inked? Was it contingent upon getting an appraisal at
well, it's
the sale
contingent
price?
on bank financing, so if the bank has an appraisal done, you can only get financing.
Right, based upon that appraisal.
Right, or you
Right,
bring in the difference,
right.
and most buyers don't have
Okay,
the
so the
difference.
deal, the deal dies unless
the-
they come up with a new deal.
Well, the agent verbally said that here's the appraisal, and then we wiggled around on concessions, so the bottom line's roughly the same. However, another agent came in with a cash buyer. And I hadn't seen the addendum adjusting the price or concessions yet, so I said, go ahead and show it.
Yeah, if the
But
first
here's
deal-
what the cash offer is gonna have to be.
yeah, if the first deal's dead because
Well,
they
it's not
can't get
dead, it's
financing.
verbally accepted. I've not,
There's no such thing as verbal acceptance of a purchase agreement.
Right.
The statute of frauds says that an agreement for or upon the sale of an interest in land must be in writing, signed by the party to be charged.
you don't know how many people out there get upset when they verbally accept something and then somebody else comes in and,
Preempts them.
preempts them, yeah.
Life in the big city of Jackson.
Well, that would be the
happens.
big city of Michigan.
Yeah,
Big
it's
state of
actually,
Michigan.
every state has a statute of frauds requiring that the
So it's a federal.
conveyance or sale, it's not federal law, it's just state law, and it makes sense, you know, it's just, we consider real property to be of such importance that we're not gonna, generally not gonna enforce agreements unless they're in writing, signed by the party who are to be bound by that agreement.
So my seller could have accepted the cash offer.
Well, it depends upon how the first one read. If it said this is conditional upon obtaining a mortgage for thus and such amount, you gotta remember the purchaser can waive that particular condition. There's
Right.
a case in Michigan that says the seller isn't entitled to terminate the deal because there's no mortgage which satisfies the condition. If the buyer wants to waive that condition, the buyer may do so. You have to put in, if you want the seller to be able to terminate a deal because the buyer was unable to qualify for the mortgage and meet the contingency, you gotta put in specific language that says the seller will have the ability to terminate based upon that inability.
Or you accept that offer as a backup and you go to the first offer and say, we've got a backup cash offer, so either you keep the one,
Either
the
you waive
original
either you waive the
purchase agreement or-
contingency, right, you do it
Right.
as a backup, that's
Right.
your safety valve, as a real estate licensee and as a seller, because what
Mm-hmm.
you don't wanna do is you don't wanna sign a second deal and lo and behold, get sued by the buyer on the first deal saying, hey, we have waived that contingency, we don't care, we'll make up the difference. But yeah, you gotta be careful.
but make sure that cash buyer has cash in hand. Proof of cash,
Well,
if you're gonna play that game.
again, now you're getting into a different issue. On the same thing is true on the first deal. You are looking for a pre-qualification or pre-approval letter
Right.
as a seller because you don't want to tie up your property for a period of time only to find out that the buyer can't qualify.
Greg's falling asleep. I hope our audience isn't.
Oh,
You're not as,
I'm sure.
He's
An example.
he's been up since 2:30 in the morning.
Yeah,
what time do you go to bed?
I don't,
9,
I don't-
8, 7?
yeah.
Right. So yeah, I mean those are just some of the issues that you face.
Well, what else happened?
What, to me?
Mm-hmm. You've been disappeared for the last 3 or 4 weeks. On sabbatical.
Oh.
Radio sabbatical.
I've got so many cases going on, Laura, I can't think of anything in particular that you might want me to have to address, okay? So,
I'm trying to think of some of the questions that have come in and asked.
as long as
you.
they're not political questions, I really don't want to deal with Jackson politics this morning at all.
Oh, I
None of those
Didn't even
issues.
cross my
All
mind.
right, okay.
Never.
You know, Greg, that is one of the problems with her being on city council, is we have these conversations. You know, it used to be nice conversations between a husband and wife. Now she comes home and it's nothing but city politics and what's happening and, you know, how do you do this, how do you do that, et cetera. So,
Well, that's because I think you're so brilliant that you could give me some insight.
Greg, it's actually because she wants free legal advice.
Life of a politician.
Is that what it is?
It never goes away.
That's unfortunate.
It's 24 hours a day, isn't it?
Well, you know,
Don't you
people
find?
are concerned about their municipality and they want to live in a good they want to live in a good city.
Sure.
That's just we all want to live in a good place. Don't you?
I'm living in a good place.
Right.
Without deer.
Don't they, when they do that deer kill, don't they
So-
like donate
Yeah,
the meat or something?
yeah.
All right.
That's
So,
a good thing.
yeah, so, no, I don't know. I mean, I just have a ton of lawsuits going on over a whole variety of subjects. One of the most recent things is we're trying to reserve an easement across property that my client is selling, but it happens to be an industrial site that has a cell tower on it. And so we want to reserve the easement and keep the cell tower rights. But that leads into a conversation of easements, which happen on residential properties as well. So you want to talk about easements? You wanna talk about land contracts?
How much time do we have, Greg?
You don't have a lot of time, you only got a few minutes here, but what do you wanna talk about?
Well, the market's getting better. We have 4 minutes, we could talk about the market getting better.
Well, market's also getting better for vacant land, I sent you that
Oh,
article
yeah,
that
new
appeared
construction.
recently.
I wonder how we should have someone from the builders, well, Kent Tyler could tell us on Saturday. Somebody should call in and ask him or leave him a note, because you're probably not here on Saturdays, are you?
Yeah, but why don't
Are you here on Saturdays?
Yeah.
Oh,
Okay, why don't you tie it into your radio show on real estate, because now that vacant land is starting to sell, you're gonna have to deal with issues of buyers who are buying vacant land or who own vacant land and now are gonna build houses on it. Things like builders who, if I own a lot and I hire a builder, some builders actually require as part of their contract, or try to require as part of the contract, that you convey the property to the builder, and then the builder will reconvey the land and the building back to the owner. And the reason they do that is because they want to get around the Construction Lien Act. So that's one thing you
so
watch out
what's
for on vacant
what's
land.
your security as a property owner
The
of
secu-
you not taking off with my land?
That's
Which you're not
exactly
gonna
right.
take off with my land, but you know.
Yeah, it's a little hard to abscond with that
Right,
land
but
to
I mean,
another
how do I know I'm
jurisdiction.
gonna get title to my land
That's the
back?
point, but you wouldn't believe how many vacant property owners who hire a contractor whose lawyer has told them this is the way to get around the Construction Lien Act. They actually are naive enough to go along with that particular proposal, and you never, ever, ever do it. And then the other thing you have to do is, even though you retain title to the property, and there's another reason not to do it, is
Why do you
because
want to get around the lien act?
the builder, because if the builder has to go through the process of the Construction Lien Act, they end up having to file a lawsuit, they end up having to actually take the period of time in order to enforce the lien against the property, and then have the property or the improvement sold to satisfy the debt. So as a builder, this was a common practice back in the 60s, 70s, and really has lingered up until the 2008 recession hit, where some builders would try to get the landowner to actually convey the property to them. One of the difficulties was that is you had uncapping since 1995 in Proposal A. But you just watch out for that. All my point is, now that vacant land is starting to sell and we're starting to see building, is you might want to add to your agenda for the radio sessions, things to watch out for on vacant land.
Well, people could email me some suggestions of topics they want us to talk about.
Sure.
They could email me at laura@7803800.com. When I'm looking at the statistics right now, which is pretty interesting, right now the average traditional sale, which is somebody who's not distressed, is 127.6.
That's a good side.
127.6.
127,600.
Right, right.
That's up, isn't
They
it?
knew what we was talking about. Compared to last year, it was 102.9.
That's quite a bit.
Yeah, quite a bit. Our average sale price last year at same time, so what are we in, September? So August, through August, was 86.5. And, but that's the whole market. Foreclosures are 37.5% of our market right now. Compared to last year, it was 42.9%. So you can see that foreclosures are dropping. That's a good thing. I'm just doing some math here.
Yeah,
Wrap it
well,
up is what Greg has given me the motion. Either that or go in circles, one or the other. I'm going with wrap it up.
Wrap it up.
So we've had a 24% increase in property values
That's
over last year.
pretty good.
That is awesome.
In sale
We
prices,
have-
in sale prices.
In
not-
sale price.
right, not property values.
And we're short listing, so give me a call. I've got 2 properties I'm going to talk to this afternoon. So people are starting to get their properties back on the market. 780-3800.
Just because you buy local.